stand adjourned. All right, do exactly.
Yes, Your Honor. Thank you.
Good morning again, Mr. Coleman.
Hey, good morning, Mr. Hoover.
Oh, yeah.
Thank you.
So yesterday, during your direct with the state, the two of you spoke about certain pictures from Instagram that you uncovered throughout your investigation. Is that correct?
That I reviewed, yes, sir.
That you reviewed. I want to hand you, Your Honor, may I approach the witness? Yes. I want to hand you what's been marked as State's Exhibit 157. Your report, I believe it's page 99.
Yes, sir.
Do you remember you and the state talking about that video? I'm sorry, that picture?
Yes, sir.
And for the record and for the jury, this is the picture where it's a picture of Mr. Coleman's hand, and the letter lowercase I is on one finger, capital S is on one finger, capital K is on one finger, and the number 8 is on another finger. Is that what you're looking at?
It's Mr. Conley's hand.
Conley, I'm
yes,
sorry,
sir.
not Mr. Coleman. Yes. So the I skate 8. Do you remember you and the state talking about that picture?
Yes, sir.
Now you know the I skate is not gang affiliated in any way, shape, or form, don't you?
No, sir, I don't.
You don't know that? Are you aware that the I skate is actually a skating brand or a skating company?
I'm not aware of that, sir.
Are you aware that this brand creates surfboards and ice skating equipment and rollerblades and skateboards, and they hold competitions? You didn't know that at all?
I'm not aware of the company, sir.
Okay. Do you remember when you were talking about your training and experience with the state yesterday?
Yes, sir.
And while you were discussing your training and experience of what you do to ascertain information, you said one of them is a quick Google search.
Yes, sir.
Is that correct? So did you Google I skate the exact same way it's tattooed on Mr. Conley's hand?
No, sir, I did not.
Did not. So you didn't have any context to what the letters and the number actually meant because you didn't do anything to find out. Is that what you're saying?
I did have some context, sir. Okay. Mr. Conley had made the Instagram post associating the ice skate with the gang with the Elm Street Pyrus. So he made the association there, what that means to him, and I believe I talked about it earlier. I don't know what it means to him. He made the joint association.
Oh, he did. Okay, so can you please, I don't remember seeing that. Can you please show this jury what information Mr. Conley posted that says Pyru owns Ice Skate, the Ice Skate company or Ice Skate brand?
I didn't make that connection about ownership, sir.
Okay. So my question is, do you have a piece of evidence that shows that Mr. Conley made some type of statement that says Pyru or the Bloods own the Ice Skate brand?
There is no statement about ownership of the brand, sir. It's an association that he made associating Ice Skate Mob with Elm Street.
Okay. How? Do they go on like group retreats and go ice skating together?
Not that I'm aware of, sir.
Do they go to skateboard parks and go rollerblading together?
I don't know.
Okay. So you're saying this, but there's no piece of evidence that you can show the jury that demonstrates what you showed them yesterday is actually gang affiliated to the Bloods or Pyru or anyone, can you?
I'm sorry, I'm trying to locate that post right now, sir. Yes, sir. So on page 85 of my report, and I'm sorry, I don't know the state's exhibit number, but there's a posting that says 700 block, Elm Street, Piru, Turf Runner Nation, Ice Skate Mob. We discussed it on direct from the state as one of the postings that was made making that association.
Okay, so he did talk about 700 block, and we understand you know what that's gang affiliated, and he did talk about the other one. But how does Ice Skate, what affiliation does the Bloods or Piru have with Ice Skate? That's what I'm trying to find out.
Yes, sir. I don't know what the direct affiliation is to him. It is him demonstrating that outwardly, saying the gang with that. What it means, he would have to clarify, sir.
Okay, so as of right now, you have no information as to the affiliation between Ice Skate and the Bloods?
Outside of that post, no, sir.
All right, so even though you have no affiliation or no actual context to the affiliation between Ice Skate and the Bloods, you and the state still presented it to the jury as if it was part of the gang evidence.
He made the association. What it means, the defendant would have to answer, sir.
Now, when you first spoke with the state yesterday on direct, he went over your training experience, correct?
Yes, sir.
Okay. And afterwards, he asked the judge to certify you as a gang expert in this case, correct?
Yes, sir.
All right, he certified you as a gang expert so you could explain to the jury what evidence you collected and how you can prove the affiliation of gangs. Is that correct?
Yes, sir.
So now your testimony is, well, the state's gang expert needs somebody else to help them understand their own evidence?
No, sir.
Okay. So we go back to you as the state's gang expert presented evidence to the jury, and you have no actual context of the affiliation between Ice Skate and the Bloods or the Piru or anyone, correct?
I've explained the posting. He made the association. What it means is the defendant would have to clarify, sir.
And you testified yesterday that context is important, isn't it?
It is.
So you presented evidence to the jury, and you have no idea about the actual context of it.
It's a posting that was made on an account that's covered in gang evidence, sir.
So that's a yes, you did. We'll move on. Now let's talk about the nexus. You're aware, or I don't know if you're aware. Have you seen the indictment in this case?
I have not seen the indictment.
Okay. Are you aware of the charges that Mr. Conley is facing?
No, sir.
Okay. I'm just going to show you. For the record, I'm showing you the most recent copy of the indictment that I have. Go ahead and look over it. Let me know when you're ready to talk about it.
Yes, sir. All right, sir, I've reviewed it. Thank you. Thank you.
Now, since you're the state's gang expert, well, let me back up for everybody. So, and the jury's heard the judge read the indictment a number of times now, but Mr. Conley is being charged with murder, felony murder, aggravated assault, criminal damage to property, and possession of firearm during commission of a felony, and a number of gang charges. And since you're the state's gang expert, I would like to go over the gang charges with you in reference to the evidence that you presented to the jury, okay?
Yes, sir.
Now, counts 9 and count 17 deal with the gang statute, which is 1615-4 for the record. And in regards to count 9 and count 17 specifically, it deals with subsection A of the gang statute. So that's what we're going to focus on right now. And just for the jury's understanding of it, subsection A deals with conduct or participation in gang activity, the in furtherance of the gang aspect. So that's what we're going to be dealing with. Now, based off of your investigation, the part that you did in this case, you don't have any type of evidence to present to this jury that shows that the blood somehow received proceeds because of the acts that occurred that Julian is being charged with, do you?
No financial remuneration in this case, sir.
Okay. You don't have any evidence to present to this jury that shows that these acts were committed in such a highly visible manner that the witnesses were like, yep, the Bloods did that, the Pyrus did that, do you?
I would say so, sir, with Mr. Conley wearing the Pyru shirt in that manner, yes, sir.
Which witness do you remember ever saying that?
I haven't seen any of the witnesses, sir.
Okay, so my specific question to you was, do you have any evidence that you could show this jury that it was done in such a highly visible manner that one of the witnesses said the Pyrus did that?
Again, I haven't heard any of the testimony that the witnesses have set up here, but from the video footage that I've observed, yes, sir. I mean, it was in a very highly visible manner in the middle of the street. It's not like it happened inside a structure, residential dwelling, or anything like that.
True. So let me set up a little something. A lot of people took part of the entire investigation. You would agree with that, correct?
Sure.
Okay. More than one person?
Yes, sir.
Okay.
Yes, sir.
And whoever took part in the investigation, they most likely came in here and testified at some point during this trial. Would you agree with that? You're not the only witness.
Yeah, certainly. Yes,
Okay.
sir.
So your sole part of this investigation deals with the gang aspect of it, correct?
Yes, sir.
All right,
As
so-
it relates to the defendants.
Yes. So just like we heard from everyone else, now I'm asking you specific questions about your investigation and the evidence you collected and reviewed.
Yes, sir.
Now, my specific question, we know a shooting outside is public. That's not my specific question. My specific question is based off of your investigation and the evidence that you reviewed. Do you have anything to show this jury that these acts were committed in such a highly visible manner that the witnesses said, that was Pyru who did that? I know exactly who it was. That was Pyru.
I'm not sure at this point. This has been asked and answered 3 or 4 times.
He hasn't actually answered the question yet, Your Honor.
Again, I'd refer back to the video footage, Your Honor.
Thank you, Your Honor. Do you have any evidence to present to this jury that the victims said, I know exactly who that was Pyru who did it?
Not the victims, no, sir.
Do you have any evidence to present to this jury that the purpose of these acts that Mr. Conley is being charged with was to establish, reinforce, or enhance the Blood's reputation in any way?
Yes, sir. So that action being committed in front of other individuals that are affiliated with the gang increases his own stain, his own reputation with the fellow gang members that he's in the area with.
So when I go on Wikipedia and I type that in, it says the exact same thing. What I'm asking you is based off of your investigation, based off of the evidence that you reviewed, can you show this jury a piece of evidence that the purpose of these acts were to establish, reinforce, or enhance the Blood's reputation? Can you show them something?
Once again, I would refer to the video footage, sir, and it's consistent with my training and experience and understanding that that is the conduct that gang members engage in, particularly when in the presence of fellow gang members.
So that's a no. Let's move on to the next one. Do you have any evidence to present to this jury that you found yourself and that you, throughout your investigation, that other Blood members were referencing these specific acts on social media saying we're the ones that did this?
No, sir.
Do you have any specific or any piece of evidence whatsoever to show the jury that other Blood members are referencing this on social media saying, or for a way to intimidate other people? Look what we've done once, we'll do it to you too.
Not on social media as it relates specifically to this shooting incident.
So basically, based on your training and experience, you know since what, the 60s or 70s that the Bloods have been in existence, that happens, but you can't show this jury how it actually happened specifically in this case against Julian Conley. That's what you're saying.
No, sir, I disagree with that conclusion. If they were to say, oh, yeah, we're the ones that went out and shot this, every single gang crime that occurred would result in an arrest 100% of the time for going on social media and admitting that, hey, I'm the one that did this and this is why I did this. I wish that's the way it was. It would make our job a lot easier, but we have to put the pieces together.
I got you. But I guess my point is, from the evidence that you presented to the jury, from your testimony that you presented to the jury, all you're saying is, since the Bloods have been in existence, this is how it happens, but I can't show you that's what happened here. That's what I'm hearing.
No, sir, that can happen. That's not exclusively the way that it happened in this case, but I mean, that is something that can happen with the Bloods.
Okay. And in 21 SC 178690-01, the state of Georgia versus Julian Conley, in this case, can you present any evidence to the jury that shows it happened in this case with these acts with Mr. Conley?
Yes, sir. Again, I would refer back to the video and understanding the context of why it happened and how it happened, sir.
All right, thank you. Now for counts 10 and count 18. Again, that's the Georgia statute 1615-4, but now we're under subsection B, which is with the intent to increase or maintain their status. So now I want to focus your attention to your testimony, your investigation in subsection B, okay?
Yes, sir.
You don't have any evidence at all to present to this jury what Julian Conley's status was before July 4th, 2020, do you?
His status was that he was at minimum an associate of the gang. As far as a specific rank, I'm not able to determine that, but he was an associate of the gang at minimum, sir.
And I believe you used the term stain.
Yes, sir.
What was his stain?
Stain is just like a reputation. It can mean a rank, but it's more about like the reputation that you bring into the gang and how you're known within that gang as someone that is that's kind of a phrase used commonly is 10 toes down, somebody that stands on their business, that's willing to do the right thing in the eyes of the gang, or somebody that backs down when confronted with any type of adversity.
Okay. So as of right now, can you show any type of evidence to this jury that Julian Conley was a YG with the Bloods?
YG is a rank, which is young gangster. I don't know any ranks that I wasn't able to identify any ranks that he had in the gang.
Okay, and that goes for OG as well?
That's correct. Any of the ranks, but that's not required under the law. We just have to find that he's associated with the gang, sir.
And let's talk about that. Can you show this jury any piece of evidence that shows when Julian was ever jumped into Pyro?
So jumped in is a term that's used for an initiation. There's different types of initiations that can be used, but his specific initiation date or any type of video where that may have been taken or broadcast, no, sir.
Okay. Do you have any piece of evidence that you could show this jury if Julian was ever blessed into the gang?
Blessed in is where someone says they don't have to be jumped in. Usually it's somebody of higher rank or origin saying, you know, this person is okay, they're now a member of this gang. There's nothing that indicates that in this case, sir.
Do you have any piece of evidence that you could show this jury that Julian was sexed into the gang?
So being sexed into the gang is another way. A lot of times sometimes it can involve with female members, usually, but not always. But there's no information that I have that he was sexed into the gang, sir.
Do you have any type of information or evidence you could show this jury who Julian's OG was?
No, sir.
Do you have any type of evidence that you could present to this jury that Julian paid dues to the Bloods or Pyro?
I don't have any information about where his money went.
Do you have any evidence that you could present to this jury that Julian collected dues from other Bloods or Pyro?
I have no information about any financial arrangements with Mr. Conley.
Do you have any evidence whatsoever that Julian's name ever popped up in a book of knowledge?
Not that I'm aware of, sir.
So all you know is before July 4th, 2020, Julian was posting stuff on social media about Bloods and other gangs, correct? Before July 4th, 2020.
Prior to, yes, sir.
Do you have any evidence to show this jury that after July 4th, 2020, and I use your quote here, his stain went up?
Yes, sir.
Show us that evidence.
It's evidence that I've been made aware of, but I don't know to what extent I can talk about that, sir.
Well, let me ask you this. Based off of the presentation that you and the state showed this jury, all of the Instagram stuff that you presented to this jury, does any of that show that Julian's stain went up?
From what we have discussed exclusively through me in this proceeding, we have not discussed any of the after effects of post the shooting incident, sir.
Okay. Now, counts 11, 12, 19, and 20, they deal with subsection E of the gang statute. So we're going to focus on subsection E. Now, subsection E deals with causes, encourages, solicits, recruits, or coerces another. However, in the indictment, all of these charges only talks about Julian encouraging. So that's what we're going to focus on, okay? Okay. All right. Can you give or let me back up like this. Can you show us a piece of evidence that shows that Julian, before the shooting happened on July 4th, encouraged other people to come with him and let's go down there and do this shooting?
So prior to the individuals manning this checkpoint and working together to kind of engage and stop these vehicles, working in concert with one another, I don't have any evidence of like how they arrived there or how they came to an agreement to engage in the conduct, sir.
Okay. And you testified yesterday that there's no group chat that he was a part of or he created, correct?
I don't know of one that exists. Not to say that there isn't one, but I'm not aware of one, sir.
Okay. And you can't show this jury that there were cell phone messages between him and other people, him encouraging people to come on down, let's do this?
I'm not aware of any cell phone that was recovered in this investigation, sir.
I believe that's all the questions I have for you right now. Thank you.
Thank you, Mr. Hoover.
Very briefly, Judge. Good morning, Agent Coleman.
Morning.
Yesterday during cross, do you recall Mr. Hoover asking you about things that happened before July 4th as it relates to this defendant exhibiting that he was going to take part in the blockade and things of that nature? Do you recall that series of questions?
I do. Yes, sir.
So, based on his activities and what you observed on July 4th, what you saw on his Instagram, do you have any doubt that this defendant, Julian Conley, is a Pirate Blood gang member?
Zero doubt.
And can you tell this jury, do you have any doubt that on July 4th, whether before, after, but on July 4th, that the Pirate Blood gang with Julian Conley blockaded and took over the area of University and Prior Street?
No doubt, sir.
And do you have any doubt that as a result of that blockade by this defendant and members of his gang, the Pirate Bloods, Secoriea Turner was shot and killed?
No doubt, sir.
Okay. Now, I want to ask you a couple questions about something that was covered today, the ice skate tattoos and the phrase. Do you recall talking about earlier?
Yes, sir.
Now, I want to show you what I think you referenced on page 85 of your report. While that's pulling up, can you tell the jurors, you kind of talked yesterday about staying up on trends and things of that nature, you see the image from State Exhibit 153 as it relates to what first says the 700 BLK Elm Street Pyru? What can you tell the jurors? What does that mean?
Yeah, so 700 block is the block out off of Elm Street. It's a common reference to Secoriea Ave, which is the neighborhood in the area that the Elm Street Pyrus claim. It's a north-south running. Secoriea is a north-south running street. You've got Elm Street that is an east-west running street. It's a claim of the territory. It's the subset. The line of the gang that is claimed. There's different blocks. There's 500 block, 700 block, 1,000 block. So it's a claim to 700 block Elm Street Pyru Bloods.
So the use of the 700 BLK Elm Street Pyru and the posting that we're looking at, is that a way that this defendant is advertising his membership or association with the Pyru Bloods?
Yes, sir.
And as you go to the third line where it says I skate mob, can you tell the jurors, based on your training, experience, number of years staying up with trends and doing research, is the association with 700 block Elm Street with the I skate mob, is that the defendant's way of associating I skate mob with Pyru Blood Association or membership?
It is.
Now, I want to talk briefly with you about some of the, well, let me talk to you about a few things as it relates to your investigation. Can you tell the jurors, as part of your investigation and contained within your report, did you get documents from Cobb County as it relates to Julian Conley's arrest in March of 2020?
Yes, sir, I did.
And can you tell the jurors, based on your review of that material, was he armed with firearms?
If I recall correctly, there were firearms that were located in a vehicle during a traffic stop in Cobb County.
And do you recall in the Instagram that you reviewed this defendant seeing posting on the put on the screen from May 31st of 2020?
Yes, sir, I recall this.
Okay. Can you tell the jurors what we're looking at here?
Yeah, so a posting saying, "Can y'all burn down Cobb County Evidence Building? I need my Glock back."
And can you tell the jurors what, if anything, that tells you as it relates to advertising things of that nature, as it relates to this defendant and the actions he's talking about prior to his arrest in Cobb County?
Yeah, so it's a reference to he had some type of law enforcement interaction in Cobb County, that something was taken from him. I know through my records review that a firearm was seized from him during a traffic stop from a group of people in a vehicle that he was occupied in. And so a posting like this is saying to the outside world, it's publicly like, hey, I had a law enforcement interaction. I want my stuff back. And he's demonstrating that by saying, I want my Glock back, that, hey, they took my gun. I'm normally armed.
Can you tell the jurors, is it common and what it means when gang members, after they're arrested, they post about their charges or screenshot warrants that were taken out after they're either released on bond or posting from contraband phones if in custody?
Yes, sir. So, I mean, that's a way to increase your stain. It's to show that you don't have any type of regard or respect for the rule of law for anyone who may be imposing their authority beyond the gang. And a lot of times that comes in the form of law enforcement, but not always. It can sometimes be the nosy neighbor that comes out and confronts you about music being too loud or something like that. So this is a way for individuals associated with gangs to demonstrate outwardly that, look, I'm willing to take on consequences for the lifestyle that I'm leading, and I'm proud of it. And so it's advertised a lot of times on social media in that way.
And do you remember Mr. Hoover asking you about specifically as it relates to financial gain and acts that are done that lead to financial gain or series of questions?
Yes, sir.
Can you tell the jurors, are there other ways for gang members like the defendant to benefit from the activities and the behaviors that they exhibit and do, like July 4th of 2020?
Yes, sir, there are. It's like I talked about yesterday. There's different ways to put in work on behalf of the gang. It can be providing funds, providing or acquiring things like weapons or vehicles or things like that. And then it can also be being willing to engage in violence on behalf of the gang or kind of be that strong man for the gang. There's different ways that you can support the gang.
Can you tell the jurors, you were asked a series of questions about things being highly visible and things of that nature. Do you remember that series of questions?
Yes, sir.
And it was, in conjunction with that question, a lot of information was asked in relation to, in regards to.
I apologize. We're out again. We can't see the witness, so that's.
Angle this your way. That help?
Yes, Your Honor.
I'm going to take a peek at your computer. I kind of lost my train of thought. Oh, that's right. I was asking about the series of questions that you were asked today and some yesterday about visibility of the actions and the behaviors of gang members like this defendant. And the series of questions related to social media postings and things of that nature. Do you remember that?
Yes, sir.
Can you tell the jurors, I want to start with the Bloods have been around for a while, correct?
Yes, sir. Generations.
Can you tell the jurors, prior to social media, recent kind of explosions, how were gangs and the things that they did and do advertised?
Yeah, so it's always out in public. It's like graffiti and stuff like that. That's how you used to be able to identify territory. When it was all about neighborhoods, it was, standing on the corner, wearing the flags, wearing the bandanas, the clothing attire, the way that speech was used during face-to-face engagement. Really, we haven't seen the shift to the digital world until really in the last 20 years, where you started having Facebook and then Instagram and all these other social media sites. And the reason that shift kind of happened is because you can get more eyes in the digital world, as opposed to how many people drive by a street corner a day compared to how many people can see a social media post. You can reach, potentially, depending on popularity, millions of individuals can see your, whatever it is on social media, as opposed to individuals that may necessarily only see, oh, here's a tagging on this street corner claiming this territory.
And can you tell the jurors, being at, it's been, framed or categorized as being at a block party where there are a number of people at the block party carrying a high-powered velocity rifle, a way to be, while wearing a shirt that shows or says 700 block or says Pyro on it. Is that a way of showing the people around you your visibility and your membership and association with the gang?
Oh, absolutely it is.
And is it a way in which to assert your dominance in that situation, like the one that occurred on July 4th of 2020?
Yes, it's essentially wearing a uniform and wearing the equipment and the attire to demonstrate your capacity to engage in violent behavior if needed or called upon.
And can you tell the jurors, as it relates to this visibility, the jurors after disrespect, like not stopping at the blockade or the barricade here, and then shooting rounds into a vehicle, how that is a way of exuding or showing your dominance in a highly visible manner.
Yeah, so I mean, it's something that occurred on a public street. You're going to have the word of mouth that's going to get around about what happened for folks that may not have been there. They're going to hear about the shooting, whether that be from individuals who were inside the vehicles that said, "Holy cow, I drove around here, and this is what happened to me," or people see the vehicle, or they hear about it on the news or anything like that. And when that type of word gets around that, hey, if you don't listen to these guys, if you don't do what they tell you to do, this is what's going to happen to you. So that type of reaction to not following the direction and the orders of these individuals who are out here with these guns and this blockade and whatnot, there's a direct correlation between, by engaging in that type of immediate conduct against people that oppose their authority on that scene, has immediate repercussions.
Can you tell the jurors, is social media the only means or way through advancing technology to exude or show this highly visible assertion of dominance and power as it relates to a gang, specifically here, Private Blood?
No, it's not the only way. I mean, it's certainly a powerful means to convey information, but it's certainly not the only way.
You talked about the news. Is the news another powerful, far-reaching way to advertise for free your dominance and your association with a specific gang?
Oh, absolutely.
And can you tell the jury, based on the information that you reviewed, spoke yesterday about seeing things on the news, did this incident, did the murder of Secoriea Turner get national news?
Yes, it did.
And you, through your review, did you see the bolo or of the defendant wearing a red Pyru shirt that was released on the national news?
Yes, I remember seeing the news article myself.
Can you tell the jurors how that is a form of highly visible, free advertising for this gang, this defendant, and the violent acts that he committed?
Yeah, so it increases the notoriety not only of the individual, but also while they're wearing that, for lack of a better term, uniform representing the gang out there, it increases the notoriety of the gang at a national level as well.
Would you agree that that reaches farther than any social media posting with the defendant's however many followers?
It can, yes, sir.
Now, I want to play you a video that we watched yesterday. This is a video that's referenced in your report as well. You found it states it was 153.
I really don't play, nigga, keep a gun. I keep a Glock G-locked in my back pocket.
Can you tell the jurors, did you hear where the defendant said he keeps the gun G-locked in his back pocket?
Yes, sir.
What does that mean?
It just means having it tucked away back behind your back.
Pocket rocket, let it pop it, let it go berserk.
Did you see the sign where the defendant was wiping his nose, said that let it go berserk as he's talking about his gun?
Yes, sir.
Can you tell the jurors, based on your training and experience, what does that mean?
So let it go berserk is basically shooting off a lot of ammunition from the weapon, just letting it go, letting the trigger go on it, and then the hand sign is a reference to slime. You're so slimy. You've got the snot dripping out of your nose, and you're wiping it away. So you see that hand sign and gesture used a lot to represent individuals associated with the Bloods, particularly from Atlanta.
Stains on my shooting on my t-shirt.
Did you hear the part where he said, stains from the shooting on my t-shirt?
Yes, sir.
Can you explain the significance of that line as it relates to this video and this defendant's advertising and bragging about shootings and stains?
So stains from the shooting on my T-shirt, it's a little bit of a double entendre. It means the stains that I'm so close to the action that I'm actually getting the blood on me, but also it's a reference to stain, like because I'm doing this, I'm getting that stain. I'm acquiring more stain, more reputation for my status within the gang.
Is that a means or a way of increasing one's status or maintaining one's status in specifically this game, Fiery Bloods?
Certainly.
Is that what we just watched in States 23? Is that a way of bragging about your status increasing and being maintained?
Yes.
All due while doing violent acts?
Yes.
Sorry, I'm looking at it. I don't have any further questions.
This will be real quick. The state just showed you a video where you're saying because teenage Mr. Conley was rapping on social media, that's a way for him to increase his stain, correct?
It is a way to make claims to increase that stain. Yes, sir.
That's perfect. So I asked you, can you show the jury some piece of evidence that you have that he increased his stain because of what he's being charged with? Now, you showed us where he could possibly increase his stain from a teenage rap video. Can you show this jury where he actually increased his stain from the acts that he's being charged with from July 4th, 2020?
I would once again reference to the video of the shooting, sir.
No further questions, Your Honor.
I just have one. Is getting national news where you've asserted your dominance as it relates to a specific area in solidarity to one of your gang members who was killed, and then doing violent acts that are then nationally televised, a way of highly visible advertising?
Yes.
Is a way in which it's free advertising to increase your status as it relates to the violent acts that were committed.
Yes.
And is that an example that Mr. Hoover just referenced?
Yes.
Thank you.
Again, we can talk about that as much as we want to. Can you show the jury that it actually happened? It's possible, yes. Did it happen here with Mr. Conley? Can you show us that?
I believe that the investigation concluded that Mr. Conley was responsible for the shooting. Yes, sir.
Can you put something in front of the jury that shows us that specifically to Mr. Conley? Yes or no?
I don't have the video directly in front of me to display, sir.
No further questions, Your Honor.
Is the national news an example of exactly what Mr. Hoover's asking for?
Yes.
Nothing further.
Is the national news in front of the jury right now?
No,
Is it evidence in this case right now?
I don't know.
No further questions.
No further questions, please.
Yes, Your Honor, no objection.
Thank you, Your Honor.
Your Honor, at this time, the state of Georgia rests.
We'll have some housekeeping.
All right, for the jury.
All right, one moment. I was not expecting to be up here right now. So, Your Honor, in the indictment, Mr. Conley is being charged with violation of Street Gang Terrorism and Prevention Act and counts 9, 10, 11, 12, 17, 18, 19, and 20. Now, regarding Now, when it comes to the Street Gang Act in the state of Georgia, it's a little different than the other crimes and charges that a person could be facing. And I say that because what the state has to prove varies on what part of the statute that the state charges under. So obviously for the entire statute, one thing the state has to prove is that a gang exists. We got the Wikipedia version of, yes, the Bloods have been in existence. Yes, they were created because of the Crips. We never said the Bloods didn't exist. Yes, the state proved that the Bloods existed. When we move to the next point is that Mr. Conley is a member or an associate of the Bloods. That's where things get a little fuzzy. And I believe the witness, Mr. Coleman, that testified kind of figured that out because he completely abandoned membership and went straight to, well, I know he's an associate. I only have to prove he's an associate. He did that because we all know that's how they're trained to do when they can't put any type of association to it. So we agree that, well, let me back up. We agree that he did say there's an association. However, Your Honor, when we get further into my argument, I hope it's more clear why I don't believe they properly address that element in the statute. The third one is that some type of act happened, and that act falls under street gang activity. Now, that's an interesting one, Your Honor. I will admit for the record that Mr. Conley is also being charged with murder, felony murder, aggravated assault, criminal damage to property, and possession of firearms or commission of the felony. Point one, I admit that those acts do fall under that statute, that they could be gang activity. But because I have to go into the nexus argument, I'm arguing that they didn't prove that simply because those acts fall under there, that there was actually gang activity. Does that make sense so far? Okay. Now, I would like to first quote Rodriguez v. State. That's 284 Georgia 803. That's a 2009 case. And that case takes the position that the commission of an enumerated offense by a defendant is not in itself sufficient to prove the existence of criminal street gang activity. And in no way am I saying that we agree that Mr. Conley committed these crimes. What I'm saying is the crimes that Mr. Conley is charged with, simply because they were committed, doesn't automatically mean that it was street gang activity or a street gang actually did it in furtherance of. So that's why I always start with Rodriguez v. State. Now, what we heard, well, let's start with subsection A. Subsection A deals with the conduct or participation, simply basically what we were talking about, but it's in furtherance of the gang. Now, what Mr. Coleman did is he got up here and he gave us a generic history about the Bloods. I mean, anyone with Netflix could literally do the exact same thing. He didn't add any specific or extra information that I believe an expert witness should be able to provide to somebody, especially in Atlanta, especially since the Bloods have literally been on TV, more so for the Fulton County District Attorney's Office than for Mr. Conley or anything else in the last couple of years. So, yes, he talked about the Bloods. When we get to the point to where everything that Mr. Coleman said was, well, this is what Bloods do. This is how Bloods act. Well, this is what could happen. This is possible. He never once said this happened in this case. So in regards to retaliation, Mr. Coleman did say, yes, people do this for some type of retaliation. And at the end there, the state and Mr. Coleman it kind of sounded like they were hinting at that Rashard Brooks was a Blood, and all of this occurred because the Bloods were doing something for retaliation. It kind of sounded like they were headed down that path. So I just need to head that off now. There's been no testimony of that whatsoever. That is completely untrue, so they didn't fix that part. Mr. Coleman spoke about the power and the respect because it's in this public area. But, Your Honor, any shooting in public is public. It takes more than that to show that the Bloods, and not even the Bloods, but Mr. Conley, through the Bloods, got some type of power or some type of increase. At the point where I asked specific questions about whether or not this was done in a way to where he could show us that the Bloods were claiming responsibility for it, his response was, well, that's how it happens when people are out there and they're shooting weapons and they have red on. Well, that's how it happens. And we agree. In the last 60 or 70 years, it has happened like that before. But the point I was trying to make, the specific questions I was asking was, did it happen here, and show us evidence that happens here? His responses were always, well, it's possible, and then it's, well, it doesn't happen all the time. But that's not the point. The Bloods as a whole aren't on trial right now. This is the state of Georgia against Mr. Conley, and my specific questions were, can you tell that because of what they're claiming Mr. Conley did, the Bloods claim responsibility, other members claim responsibility, other members suggested that it was for intimidation? Mr. Coleman, he couldn't do it. But instead of just saying, no, I can't, he did the little circle that officers always do, is, well, this is how it always happens. That's why I asked specific questions when it came to this specific case and these specific circumstances and this specific defendant. Another question I asked was, since it was such a highly visible manner, show us evidence where some of the witnesses were like, well, yes, we know it's Pyru, yes, we know it's the Bloods. He couldn't do that, Your Honor, and we know from all of the testimony, that was never said. Not one single person said that the person in red shirt and white lettering was the shooter. Not one single person said the person that was dressed as a Blood, like Mr. Coleman said, the Blood uniform was the shooter. Not one person that witnessed the event, the one person that was out there, period, said that the person that was Pyru was Blood. So the simple fact that a shooting happened, and a simple fact that that shooting falls under the statute, and a simple fact that Mr. Conley was wearing red, it wasn't to the point where it was highly visible where anyone said, I know it was the Pyru because of what he was wearing. That goes for the witnesses, and that goes for all of the victims as well. I believe the McCords, they never once said that the person in the red shirt with the Blood uniform was the person that committed the crimes against them. And then Ms. Turner and the driver, they never once said red either. They always said black. They always said something completely different. They never once said, so I don't believe the state went to the point to prove that this was done in such a highly visible manner that they knew the Bloods were the ones that were doing it or Pyru were the ones that were doing it. We heard more about bounty hunters and the Buck 12, I don't give a NFAC. We heard more about them. We didn't hear about the Bloods at all. The only ones that brought up the Bloods were officers after the DA's office requested GBI to come in to look for gang evidence. So that's why the highly visible part, even if it was done outside, yes, all of them are done outside, but there has to be that extra step. Was not done here. There's no evidence that the Bloods did this for intimidation and other people actually knew they did it or they're actually intimidated by it, and no one ever claimed responsibility for it. Now, in regards to counts 10 and 18, they deal with subsection B, which is obtain or earn membership or maintain or increase status or position. And this is where I do believe that they showed that the gang exists, but Mr. Coleman pretty much tapped around any type of answer as to what he actually knows. We know for a fact there was no evidence presented that Julian Conley's status increased because of this shooting. There's no evidence presented that Julian Conley got some type of proceeds or some type of benefit, some type of property or anything because of this shooting. There's no evidence whatsoever that Julian Conley got more power in the Bloods, Pyru, the neighborhood, or anything because of this shooting. Yes.
Did they have to actually get that? Or is it just the intent to get that?
Well, both ways. Number one, I believe the statute contemplates that it has to be done. Just because it can be done, just because it has been done in the past, doesn't mean that it's general. I think they have to, and at the very least, they haven't shown the intent. They haven't shown that Mr. Conley and a bunch of other people took over an area with the sole basis of him getting or increasing his power or his status. Just because Bloods have done that in the past means absolutely nothing if they can't apply it to the specific circumstances in the specific case. 1 second. So again, every time Mr. Coleman would talk about status or talk about getting stained up, he always talked in generals, like it generally happens. This is how I've been trained to know it happens. But when asked specific questions about how can we say it happened here, other than the fact that Julian Conley was down in the area at the time, he didn't have an answer. And the generic answer he gave most of the time was, well, I think the video shows it. I didn't see how he got more power or control in that video after this shooting happened, before, during, or after. I do want to bring the court's attention to another case. Actually, it's encompassed under the one I gave you, so they quoted it, so we're good on that.
Okay, it's encompassed under Rodriguez?
Yes, Your Honor.
Okay.
The next, so we're still in subsection B. I still don't believe that the state has reached the burden to prove the status, the increase, the maintain, or anything like that. At the very least, the state didn't even show that whatever association Mr. Conley had before the events happened on July 4th, 2020, even remained the same. And when I say that by saying, it's clear Mr. Conley posted, or he was a teenager. I mean, he used social media like most teenagers do. There were thousands of pictures. There were hundreds of videos. There were text messages. There were group chats. The state had all of that evidence and information, and none of that came in because none of it showed anything changed. I'm sorry, Julie. This was a stupid kid that was posting stupid stuff on social media, but it never showed that his status or his association with the Bloods, with Pyru, or anyone else ever changed. At the point, Your Honor, to where the state couldn't even give us a name of other associates that were either under him, above him, or actually with him. He was a stupid kid posting stupid stuff on social media, trying to be a rapper like literally 98% of my clients do right now. They didn't even prove that there was even the same between before it happened and after it happened, so we don't believe they've met the nexus when it comes to subsection B. The last subsection is, the last counts 11, 12, 19, and 20, and that falls under subsection E. Surprisingly, well, not surprisingly, I'm impressed that the state only charged with the encouraged section of it and not all of it. That says a lot. Now, in regards to encouragement, that's why I had to do that timeline to walk Mr. Coleman through it. So we start anytime before July 4th, 2020. There was no evidence whatsoever that Mr. Julian was around any other person that was at the scene the night of the shooting. There are no text messages, there are no phone calls, there are no pictures. They weren't staying together, they weren't hanging out together, they weren't playing video games together, they're not in rap videos together, none whatsoever. Leading up to the day of July 4th, 2020, there's no evidence whatsoever that he was with any of them that morning of. They didn't have conversations about doing anything. There was no common interest or common knowledge of Julian coming up to tell people, hey, let's go ahead and take care of this. He didn't encourage anybody to do anything leading up to the event. So then we get to the actual event itself, the shooting on the evening of July 4th, 2020. Now what Mr. Coleman suggests, he didn't actually prove it. I think he just suggests that because Julian was there with other people and he had a gun, well, that encourages other people. That's kind of circular logic, Your Honor, because he was there, because he had a gun, and because other people did something, that means he encouraged them by just being there. That doesn't quite add up in my book, Your Honor. For an example, Mr. Coleman tried to say that he could show that Julian was encouraging or leading, actually, because the guy in the black at the MARTA bus stop, or the MARTA surveillance, looked at him for something. That's not true at all. We saw the video, and the guy that was dressed in all black, he actually was the one that was in control of everything. He's the one that actually said, oh no, he told the driver, oh no, you're good, you're part of the community, you can come through. And then he shirt in a wheelchair, he actually helped him, escorted him onto the bus. Julian didn't encourage anybody. He didn't provide weapons, he didn't provide transportation, he didn't provide ammo. Clearly, Julian has ammo because he's been arrested with a lot of it. He didn't do any of that. There's no evidence whatsoever that he formed a common intent or a common goal with anyone during this incident that happened. And finally, afterwards, Your Honor, again, he posted, I mean, there's nothing. There was no communications about it with everyone else. There were no meetups with everyone else. There was no, there's absolutely nothing. It was like radio silence afterwards. And it's because there was no group thought. There was no group intent with all of this. He didn't encourage anyone with all of this. I know the court's aware, simply because you're a gang member or a gang associate and you commit a crime, that doesn't make it gang activity. Simply because you're around other people that may or may not be gang members or gang associates, and they commit a crime, it doesn't mean that it's automatically gang activity and you're a part of it. Because of the way the statute is written, the state has to prove the actual gang exists, Julian was a member or an associate of the gang, the activity that he's being charged with falls under the statute, and the nexus ties it to the gang itself. Because it's possible that media attention about the shooting of, the shooting and killing of a little girl reaches a lot of people, yes, that's possible. But did it further the blood, specifically the Pyrus or Mr. Conley in this case? And there's no evidence of that whatsoever. The state showed a video of him doing a pretty bad rap, and that's possible that he could have got some type of benefit from that. I agree, he possibly could have, but he's not being charged with that video. He's being charged with these acts. At the point where I do not believe the state met their burden when it comes to the nexus, especially in regard to, say the charges, murder, felony murder, aggravated assault, criminal damage to property, or possession of firearm during the commission of a felony. I do believe that it's not enough for them to get one or two of the elements for this to go to the jury. There has to be evidence of all four of the elements, and it's possible, or that could be, or that's happened in the last 60 years that I know of. I don't believe that's enough, Your Honor, and for those reasons, we believe that counts 9, 17, 10, 18, 11, 12, 19, and 20 should not go to the jury.
Okay, thank you.
Morning, Your Honor. I'm going to briefly address the non-gang charges of the indictment. And we're asking again that those charges, that the court grant a directed verdict of acquittal in those charges. What you have here in this case is not a case where the identifications are inconsistent, but you don't have enough evidence to send this case to the jury because the identifications of the person who actually committed this crime, they are all consistent, and they all consistently say that it wasn't Julian. What the identifications say is that there was a person, and as the state indicated in its own opening, that Julian was wearing a distinctive red shirt. Well, distinctive, that word does a lot of work. It should at least. It should mean that you stand out. It should mean that people see you and people notice you and people recognize you and people remember you. It should mean something. But what you have in this case, and essentially there are 4 people that we will call as eyewitnesses in this case. You have Mr. McCord, and Mr. McCord never once mentions the distinctive red shirt that the state indicated that Mr. Conley had on. You have Ms. Conley. She never mentions again the distinctive red shirt that the defendant had on. And a bit of irony aside, she was wearing a bright red outfit herself. At no point did she ever mention someone doing anything in that distinctive red shirt. In fact, when you listen to Mr. McCord, what he talks about is a dark-skinned person who was there, and he talks about a lighter-skinned person with a shotgun. Now, apparently, there's a huge distinction between shotguns and rifles, about which I'm not familiar, but there is a distinction. And nobody ever indicated or testified, no witness ever testified that Mr. Conley ever on that July 4th day had a shotgun. So the McCords aside, moving on to Ms. Turner and Mr. Ivory. Once again, their descriptions are consistent, and they are consistently not Mr. Conley. What you have Ms. Turner saying was that the shooter or shooters had on black. One person had on all black, dressed like we've heard cop, we've heard bounty hunter, but one person had on all black and a mask, and another person had on black pants and a t-shirt, I believe, or wife beater or undershirt type shirt is what that person has been described. And once again, going back to that distinctive red shirt the state talked about in its opening, no, Ms. Turner never mentioned anyone in a red distinctive shirt with white lettering on the back or red at all. Now, as far as Mr. Ivory, what he testified to, same thing. He talked about the shooters wearing black, and his testimony was even about a photograph he brought in with two people circled. One person was taller and darker with a beard, and the other person was shorter and lighter. But again, neither of those people were Mr. Conley. So this is not a case where there is no identification, which should get to the jury, I guess, or a case where one witness said it was a defendant, another witness said it was a different defendant, so you have inconsistent identifications. In this case, you have consistent identifications, and they all say it was somebody other than Mr. Conley. So based on the consistent identifications, inconsistent with Mr. Conley on all remaining counts, and I stand and I adopt everything that was previously said by Mr. Hoover, I ask that the remaining counts be dismissed as well, Your Honor.
Thank you.
Good morning, Judge.
Good morning.
As the court is more than aware, when looking at a directed verdict, the court is to look at the evidence in the light most favorable to the non-moving party, here obviously the state. And based on the totality of the evidence, the circumstances of all the testimony that has occurred and has come through eyewitness testimony and expert testimony, there's more than enough evidence for all counts as it relates to this defendant to proceed for the jury to make a conclusion or a decision as it relates to the state meeting its burden of beyond a reasonable doubt as it relates to each count in the indictment. I'd start with the gang counts that defense counsel first referenced for the court. I don't know if we were in the same place at the same time, but it's clear that this defendant is a member of the Piru Bloods, not only through his associations and activities and videos, which his entire Instagram account in its entirety was admitted into evidence over no objection as it relates to this defendant. And as referenced by Investigator Coleman, the hundreds and hundreds of videos and photographs that he saw where this defendant was claiming his involvement in the gang, not to mention his own autobiography where he admits that he is a Piru blood gang member. He literally says, before I was a Piru, I was a G-Shine member. He outlines his entire gang membership from when he first lived in St. Louis, Missouri, and then into Compton, and then how he brought the principles of his gang here to bang throughout the city of Atlanta, I think were his exact words. So as it relates to his membership, not only association, but membership, his own words show that he is a member of the Piru Bloods, and has been a member of the Piru Bloods for as long as he can remember. It seems as if from when he was a teenager till now, in his activities that Your Honor saw and the evidence showed that he's still repping in the Fulton County Jail. As it relates to subsection B, the statute itself says that it is the intent that is what is relevant, not actual showings as defense counsel referenced. It's just the intent as it relates to that count. I'd further, I guess, bring to the court's attention that B doesn't require the specific nexus like subsection A does. It's strictly the commission of the act plus the gang intent, which is the wording or the language of the statute. I'd also submit to the court that an armed individual, this defendant, with other members of his gang, wearing not only gang colors, but gang paraphernalia written on the back of his shirt. You heard all about what 700 block of Elm Street means, that he's got Piru written on the back of his shirt, while enforcing a barricade and a force, I guess a show of force and authority in honor of a fallen gang member. And yesterday I was pretty clear through, I believe it was State's Exhibits 58 through 62, that Mr. Brooks was being honored as a member of the Piru Bloods based on how he was referenced, the reference to Piru, I think it said Piru Love as well, spray painted on the Wendy's and in the area. So honoring a fallen gang member, how that doesn't encourage other gang members is I guess, a mystery to me as it relates to that count, Your Honor. I know Your Honor watched the videos where this defendant is directing not only Mr. McKinney but others, and with his circumstantially body language, he's pointing, things of that nature, and Mr. McKinney goes running, specifically goes running after the McCords, after the defendant points to where the McCords go. After the shooting, the defendant is doing the same thing as it relates to Mr. McKinney. You see Mr. McKinney run after the car being driven by Mr. Omar Ivory in an attempt to get Secoriea to the hospital for life-saving measures. How that's not encouraging, I'm in directing as the statute requires, again, is a mystery to me. As it relates to the remaining counts in the indictment, I think the evidence is more than clear and more than enough for all counts, the remaining counts, to go to the jury. Defense counsel referenced or talked about identification and consistent misidentification and things of that nature. Well, the consistent identification in this case is the video evidence. So regardless of what other witnesses who were traumatized and were attempting to save their 8-year-old little girl, the video itself, which has been shown from every angle, the testimony of Detective Shepard as it relates to how he was able to track this defendant because of his distinctive clothing. And let's not forget this defendant's own statement where he admitted that the person in the distinctive clothing was him. So I'm not sure how we can ignore that as it relates to a consistent identification. And a legal principle we all seem to be kind of neglecting to recognize is the whole parties to a crime statute. Whether the jury believes this defendant actually was the individual who shot the gun that caused the bullet to enter Secoriea Turner is irrelevant as it relates to parties to a crime. It's clear he was manning and participating and enforcing the authority of his gang on July 4th of 2020. It is clear from the video that he was one of the individuals that was down at the barricade at the time that Secoriea and Omar and Ms. Turner drove past the barricade in a form of disrespect. And we know that the defendant took this as disrespect because the McCords told you, Mr. McCord told you that the individual dressed in red that he saw on the news conference was the individual who said that he was acting disrespectful and one of the individuals that pointed a long gun in his face. It's lost on me how there's not more than enough direct and circumstantial evidence for the jury to get all counts of the indictment, Your Honor.
Will you talk to me about the charges based on Subpart E of the gang statute?
Yes. So, let me just make sure I pull up the correct counts, Your Honor. So, yes, Your Honor. As it relates to Subpart E specifically, we'd be looking at the first two counts would be counts 11 and 12. That the state would, I guess, submit to the court that the encouragement to participate in this illegal barricade, the encouragement that was shown in the direction that was being done by this defendant to individuals like Mr. McKinney, was that encouragement is what led to all of the acts that are referenced in the remaining counts of the indictment. Without that encouragement, we wouldn't be here today as it relates to the shooting that eventually arose in regards to Secoriea Turner, as well as the show of force and the aggravated assaults that were committed against the McCords, and the activity that we specifically saw Mr. McKinney, Mr. Conley's named co-defendant, his reaction and behaviors as it relates to after this defendant was disrespected, after this defendant communicated to Mr. McCord that he had disrespected him, and after this defendant pointed firearms, a long gun, as described by Mr. McCord, you see the direction, the encouragement that is being provided by this defendant to Mr. McKinney and the other unnamed individuals who all run after the McCords, point firearms at the McCords, committing the very same acts of aggravated assault against Mr. and Mrs. McCord, as well as in the same instances relates to Ms. Turner, Ms. Charmaine, as well as Mr. Ivory, Your Honor.
So does that code section, Subpart E, does that encompass encouraging other gang members to commit acts, or is it just a recruitment subsection?
So what I would say that it encompasses both of the things referenced by the court as it relates to ways to prove the encouragement Your Honor just described.
Okay, I'm just going to take a minute and step off the bench. I'll be back.